SJC-11897, Insurance Company of the State of Pennsylvania, v. Great Northern Insurance Company.
Good morning. Welcome to Massachusetts.
Morning, may it please the court. Barbara Michaelides from Nicoledes Fink in Chicago on behalf of the Insurance Company of the State of Pennsylvania. We're here today on a certified question from the First Circuit, and specifically that question is whether or not Massachusetts would recognize or adopt what's known as the selective or targeted tender doctrine in the context of this case, which involves a workers' compensation claim. The reason the question has been presented by the First Circuit is that Great Northern is forced to actually advocate adoption of the targeted tender or selective tender doctrine because existing Massachusetts law forecloses its ability to avoid equitable contribution in this case, where there are two co-insurers on the identical risk covering the same claim. And there's a long history in Massachusetts of requiring equitable sharing in the context where you have co-insurance for the same loss.
Can I ask you a factual question? Because it just wasn't clear to me whether there seems to be disagreement among the two sides here about whether in fact, is it progression? Is that the?
Yes, is the insured.
Yeah, whether the insured in fact affirmatively declined to tender to Great Northern, or it's not clear why that didn't happen?
Well, there is a dispute. The First Circuit accepted as true Great Northern's representations that there was an affirmative deselection of coverage.
But we need to look at it in that context.
Well, I'm not sure you do, because obviously I think that would be an issue in this case because the existing record does not actually support a deselection of coverage. So I'm from Illinois, where it's the outlier state that has the selective tender doctrine, and certainly and that's the only jurisdiction where there's any real developed case law in this area. What we have of record would absolutely never meet the criteria for an actual deselection of coverage. You would have to put it in writing. It would have to be, you'd have to invoke your rights under the Institute of London case. You would have to indicate that you were actually deselecting coverage and you were asking that carrier to take no action to not respond to this claim. We don't have that. All we have is a statement from Great Northern indicating someone on the phone said they didn't want participation, but when it came actually time to submit an affidavit to that regard, the only thing we have is an existing person from Progression who claimed to have looked back through the records and found no indication that there was notice provided. So that would not rise to the level of a deselection.
Are these two different kinds of policies? I mean, one is the compulsory workman's compensation policy, which Progressive was required by law to have.
That's ours.
Yep.
Correct.
And the other was a voluntary policy. So Progressive decided, I'm going to pay for some more alternative protection. Aren't they very different?
They're not different at all in the only thing that matters here. They both provided coverage for this exact loss. And actually the voluntary policy that Great Northern provided was designed specifically to cover this exact circumstance. An American employee traveling abroad who's injured abroad, which is exactly what happened here. Mr. Marino was traveling abroad in his duties for Progression.
So clearly he could have made a claim. There's no question.
Absolutely could have made a claim. And perhaps we suspect that the company didn't realize they actually had this line of coverage. It's in a multi-coverage line policy. And so it could have just been that it was overlooked at the time of the accident. He was seriously injured. He was the CEO. It might have just said, make a claim for workers' comp. It was made against ISOP, who
Why couldn't the customer
stepped right in.
Essentially, all right, I've got two policies. Now that I'm injured, I know what my injury is, and I know what my coverage is in connection with this kind of injury. I have a voluntary policy. I'd like to sort of keep that voluntary policy. I don't want to have to pay an increased rate. So I'm going to go with the compulsory policy. Why isn't that a choice that the insured should be able to make?
Well, that's the exact public policy considerations that underpin the selective tender doctrine in the first instance. What we would submit is that Massachusetts actually places a much greater emphasis on, and it's the public policy to actually share equitably where you have co-insurers on the same risk. That's the opposite side of the selective tender doctrine. So Massachusetts has a very extensive body of law that supports equitable sharing, is viewed as that provides a greater basis for substantial justice in these cases, and you have to compete and weigh these competing public policy interests. We would submit that Massachusetts' existing law would show that the countervailing public policy here is to enforce equitable sharing for co-insurers on the same risk. And that's not even looking at the context of this case, which is workers' comp. And I think workers' comp adds an additional layer of analysis.
Isn't it just the opposite? I mean, there is a compulsory policy here. I mean, that's what workers' comp demands, and that's where he's collecting.
Right, there is coverage here. And importantly, the insured is not here actually pressing the arguments that it needs this additional right. It's actually Great Northern who's trying to get out of paying a coverage obligation. So I think it's critical here that we don't have progression advocating for adoption of this doctrine and is not advocating that it needs this additional right in its arsenal to manage its loss history.
Go ahead.
I'm sorry.
Oh, okay.
Ms. Beltzert, I'm sorry.
If, let's say that an insured, let's say we go your way, and so there is required equitable sharing of this contribution, and an insured really does want to do what Justice Cordy just said. In other words, is buying two policies, well aware that one of them is mandatory and one of them is really, icing on the cake that the insured wants to save for other things. Could the insured do something with respect to that second policy, like say this is only, whatever the language is about, this is, we will not do, we will not share? I don't know. Is there anything the insured could do to protect its right to selectively tender if it wanted to?
Well, I think this court would have to first recognize that as a right. There's only 3 jurisdictions in the country that actually have done that because other jurisdictions that have considered it said the right to equitable contribution is an extra contractual right, so it arises independently of the contract. So it does not give the insured the opportunity
Even though it's going to mean higher premiums going forward, or could?
Well, it doesn't necessarily mean higher premiums. And because I'm from Illinois and we have quite a bit of targeted tender, selective tender cases, it's important to understand the context within which selective tender was actually originally first recognized in Illinois and kind of where it has moved in recent years and kind of come back. So the original rationale for selective tender was in cases where the parties had a pre-loss risk allocation in place, most commonly in a construction defect case where you have a GC who's working with subs and they have an indemnity contracts in place such that the GC wants to make sure that the responsible party for a loss, their carrier is paying. So selective tender is born out of that arrangement. Over time, it expanded, and it's now contracting because Illinois is now recognizing that it really only serves a purpose in very limited fact patterns where you do have a pre-loss risk allocation in place, and it allows the insured then to control that loss into the appropriate insurance for which the parties had prearranged.
Counsel, what do we do with the judge's ruling that even if equitable contribution applies, that you cannot override explicit and unambiguous policy language, which in this case said that they had to make the tender to Great Northern, and that didn't happen?
Well, that's where Massachusetts law comes in directly. All insurance policies have notice provisions, and there's clear body of Massachusetts law that in order to enforce what would be a late notice argument here, because they did get notice. They received notice from the insurance company of the state of Pennsylvania of this claim, and under existing Massachusetts law, that is sufficient notice. Notice does not have to come through the insured for it to activate coverage in a policy, and I think this court just recently reaffirmed that in the Boyle case just in September, which the amicus points out. So notice can come, and Darcy, Johnson Controls, all of these cases involved a notice to a carrier that did not come directly from the insured. So you have to put in context that there was notice here. There was adequate notice. The DIA proceeding was ongoing at that time, and Great Northern could have definitely participated had it chose to. It simply chose not to.
Under
If I
this,
can, if I can follow up on that, let's look from the point of view of the worker. The worker, who in this case is the CEO, notifies the employer, I got very seriously injured in Oman, and then notifies DIA if that's required. Does the worker need to do anything else to be covered under, in this case, both insurance policies?
It does not. Under the statute that applies directly, so the voluntary policy is called a voluntary policy, but it submits itself to the state of hire, here the state of Massachusetts. So the rules governing ICSOP's conduct govern Great Northern's conduct. And if you look at the way the Massachusetts workers' compensation system is organized, there has to be notice to the employer or the insurer, and it's then mandatorily covered by the insurer on the risk. So if you look at Section 26, it speaks in terms of shall. So if you have an employee who has opted into the workers' compensation system, once they're injured, they are entitled to benefits under the policies applicable to their loss. Here, that's both policies.
Does that mean that from the point of view of the worker, even if my employer says, I don't feel like sending it on to Progressive, I'm sorry, what's the other?
Great Northern.
Great Northern. I don't feel like sending it on to Great Northern. I'm still covered under Great Northern, even though they didn't do what they're supposed to do.
Absolutely, and that's exactly how the entire system is designed to operate. What you don't want to do is you don't want to inject too much difficulty between the injured employee and the insurer who agreed to cover this risk and accepted a premium for that. So where you do have the notice provision in Section 6, which does require the employee to give notice to the insurer, there's nothing in that provision that would ever account for not allowing coverage flowing between the insurer and the employee. This is a system designed to get the employee and the insurer together as quickly as possible with as little trouble as possible, and so that if you have an employer that has failed to give proper notice, I think they have to do it 3 times in a year, they might be subject to a $100 fine, but there's nothing in there that could deprive the injured employee of the coverage to which they are entitled by the insurer. And that's by design, and that's actually a very good policy, because you don't want to inject the type of disputes that we see here into the workers' compensation system. Because if you recognize a right to selectively tender, all of a sudden then, the entire system changes, and you now make the primary person or the coordinating person the employer, and that's just not how it is currently. The injured party can give notice to either the insurer directly, the employer, or the employer, and either way, they automatically get coverage, because you want to encourage the carriers to step in immediately provide benefits, and you want to make it as easy for the injured employee to begin to get compensated immediately after injury.
under the selective tender doctrine, if the injured employee gives notice to one of the insurance companies, and that insurance company says, nope, we're not going to cover it, go to the other guy. We refuse to either indemnify or defend. And they then go to the other guy, the other insurance company. What's the result? And does it make any difference if the first request had been made to the voluntary versus the compulsory issuer?
Well, there's no grounds to deny coverage.
But forget about that.
Well-
They do deny coverage.
Well, that's exactly why you don't want to inject target tender into workers' comp, because currently there's an immediate coverage obligation. They have to start paying immediately.
Well, somebody's going to start paying right away.
Right, and that's exactly what ICSOP did
What
here.
happens under the selective doctrine if one of the insurance company just outright refuses to participate?
Well, what you then is you've bought a huge amount of litigation typically. What ends up happening is you get sidetracked by payment. You will have carriers that would actually then say, oh, well, we've got to see if there is a selective tender in place. You're going to delay the beginning of the benefits to the employee, and you're going to then have the carriers fighting, trying to figure out, do we have a selective tender? Does this meet the requirements for selective tender? And we would submit that you really do not want to take on any of those types of difficulties in the workers' compensation context, which is really a streamlined system to ensure that benefits are directly given to the employee as quickly as possible. And we would also point out the only state that's actually ever squarely considered this question is the Utah Supreme Court, and they resoundingly rejected it on all of these public policy considerations, that you want to ensure coverage for injured employees as quickly as possible without injecting all the uncertainty that comes along with trying to figure out if there had been any type of a selective tender. And I see I'm running low on time, but if I could just quickly address one of the other arguments.
Actually, you're out of time, so thank you.
Okay, thank you.
Good morning, Your Honors. May it please the Court. I'm Jenny Sheehan, along with Rick Shea. We represent Great Northern here. And essentially, in this case, what ISOP is asking this court to do is to give it a legal right to override a business decision made by the insured in this case.
But that's the concern I have with the argument. That assumed it's your decision as to whether or not you are going to seek coverage on behalf of the employee. But is it not true that if I am the employee and I give notice to the employer, I have coverage from both by the notice, that you can't deny me the opportunity to seek coverage from both of the insurers because you choose not to pursue one of them?
Certainly, but in this, under the facts of this case, first of all, I do want to address that I do think the record does reflect that the insured was well aware that it had two policies, because when Great Northern learned of the claim from ISOP, it was approximately 20 months after the accident, they didn't sit on their hands. This is, distinguishable from the Boyle versus Zurich case, which was referenced earlier. They reached out to the insured to determine what had happened, to find out
what the
about
record shows is a letter written by a Great Northern employee saying, I was told X. I mean,
Right, but there's nothing else to dispute that wasn't the case. And at that point in time, Progression could have certainly said, oh, yes, we actually, this was an oversight, we forgot, we're tendering the claim right now. There's nothing to indicate that
But that's not my question. I mean, there may be a factual dispute. But
Sure.
let's assume that Progressive did say, no, we only want to go to ICOP. We do not want to deal with Great Northern. And therefore, we are not going to seek workers' comp insurance from Great Northern on behalf of our CEO. Do you have that right to basically deprive the CEO of his opportunity to have this alternative insurer? Now he has, before he had two sources of insurance, and if one went bankrupt or if there were other concerns, he had two sources. Is it your right as an employer to say now you have one?
Well, I think because the compensation that goes to the employee is set by statute, by tendering it to two different companies, if they had chosen to do that, it would not increase his compensation. He'd still get the compensation.
I understand that, but what if ICOP became insolvent?
I think there's there's a remedy for the, if the,
So the state
under
should
the
pay
fund.
it, so the state fund should make up for it in case the workers' comp insurer,
No, but I do think at
instead of
that,
having equitable contribution, which is a recognized doctrine in Massachusetts?
no, but I think at that point possibly the insured could still have tendered to Great Northern. I mean, this case is different because the insured made a business decision. It wasn't an oversight. It wasn't that they weren't aware, and they specifically said that they did not authorize ISOP to tender to Great
Where is
Northern.
that again?
I'm sorry?
They specifically said they did not authorize?
That's what they told Great Northern when Great Northern reached out to them. They said not only did
No affidavit to that effect.
We
There's a
don't because the,
statement by somebody at Great Northern that they overheard that?
well, that was what was told to them by Progression, but that Progression employee
That's
was,
not in the letter.
it is in the letter.
But we don't know, I mean, again, wholly apart from this, the reason for not seeking to get it from Great Northern may be because Great Northern is such a pain in the rear that I don't want to deal with Great Northern. I only want to deal with ICOP because they are cooperative, helpful insurers. Does this not mean that the pain in the rear is going to be benefited by being a pain in the rear?
No, not at all. And I think that both the courts that have heard this case previously, there was nothing to indicate that.
Well, I
Great
understand
Northern-
that, but I mean,
Right, right.
but their argument is this gives one insurer the ability to make it so difficult that the employer is going to say, I just don't want to deal with them. I just want to deal with the people who's going to be helpful. And the result of that is that employer who's being a pain in the rear doesn't now have to pay anything.
Okay, well, I would say, under the doctrine of equitable contribution, I mean, I think there's a lot of what-ifs that could come in, but under the doctrine of equitable contribution, it's not just a spreading of risk, it's that one insurer has an unsatisfied underlying obligation to the insured. And that is not the case here. There was no obligation to the insured because the insured never tendered a claim, never notified, never did anything to trigger coverage. They never took any of the steps that they would have had to do to
So you're saying that
effectuate coverage.
contractual provision trumps case law that says that that's not necessary?
I'm saying that the case law, if we're talking about Johnson Controls and Darcy and Boyle versus Zurich, that case law is not applicable in this situation where in all of those cases, even if there was someone other than the insured making the tender to the insurer or giving the insurer notice of some kind, the ultimate decision as to coverage would benefit the insured. And in this case,
In Boyle, the insured was out of business.
but there was a default judgment against them that the
only one that had benefited was the injured person,
but
except in a most theoretical way.
But there was an outstanding obligation of coverage. Here, the insured would not benefit if Great Northern.
Insured is the employer.
The insured is the employer. And the employee as well. And the employee that is being paid under the statute, he's gotten his compensation, and there's no question about that. Great Northern, if Great Northern has to contribute to this claim, it's not going to the insured, it's not going to the insured employer or the employee. It would just go directly back to reimburse ISOP for only covering what it had agreed to cover in the first place.
So does it, if we look at this as a question that hasn't been decided in Massachusetts, and we look around the country and we see that there are only 3 states, and if I'm accepting what your counsel for ISOP says, that Illinois itself is backing away. We look at this and we see the public policy. What is the reason why the public policy concerns that would militate in favor of equitable contribution shouldn't be compelling to us the way they are to most other states?
Because, well, I would, go on the selective tender issue, Great Northern has never viewed this case as a selective tender, and it's ISOP that has brought that into the mix. We've always viewed this as a contract interpretation question, so it has to do with.
Well, the First Circuit saw it as a selective tender. I mean, that's the question that we have, isn't it?
Well, I think yeah, I mean, because in this particular circumstance, the result would be the equivalent of selective tender, because whether you decide it under the selective tender doctrine or you decide it under Massachusetts contract law, the question is, can the insured purchase 2 policies and then make a decision as to how to use them, and in making that decision, decide to tender a particular claim to only one of the insurers. So I think that the public policy implications in terms of, going back to what you said earlier, Chief Justice, in terms of an insurer dragging its feet or being a pain and not being responsive, those are already addressed by Massachusetts consumer laws in 176D and 93A. So to the extent that allowing the insured to make such a decision would then trigger that kind of conduct among insurers, it's already addressed by existing law.
But the reason, I mean, the reason you seem to be shying away from it, referring to this as selective tender, is premised on the view that there is no obligation of Great Northern to do anything until the employer gives notice and makes a request, correct? You're basically saying we're not liable until Great Northern asks us to pay.
Until the insured asks us to pay.
Until Progressive asks you to pay.
Yes, well,
And
yeah.
I guess that's the premise which I'm wondering about, because the employee has said, I want workers' comp, and has notified the employer, and isn't that, under our workers' comp statute, sufficient to say you do have an obligation to pay, regardless of whether the employer gives notice to you?
But I think that in this situation, the employee said, I want insurance coverage, and the employer, Progression, obtained that coverage. Within, I think they notified ISOP the day of the accident or shortly thereafter. So everything that needed to happen in terms of getting that employee the coverage that he was entitled to under our workers' compensation scheme happened. And I think that, you know, in terms of the notice, the Utah case, and we've talked about this in our brief, but that case was decided, the court declined to decide it on general insurance law and decided it under the wording of the Utah statute, which imputed notice to the insurer of the injury as soon as the employer had it. And Massachusetts does not have anything like that.
But if the policy reasons for equitable contribution are fairly strong, and the fact that they don't necessarily in these particular facts come into play, but we are asked a question really of what would Massachusetts law do about selective tender, don't we need to look beyond these particular facts? I mean, and think about what those reasons are that you might go the other way?
Possibly, but in doing so, I think the court should not. I think the facts of this case are important because you have a sophisticated insured. I mean, I think that there could be cases where there might be somebody that has two policies and forgets why they got the second one and doesn't realize. And in those cases, I think then the prejudice, the showing of prejudice before denial of coverage, those things come into play. But here, where you have an insured who knew what they were doing because they were, I think, both fairly expensive policies, they bought the two policies. The two policies certainly had some overlapping coverage, but also there were coverages in the voluntary policy, such as repatriation expenses and things like that that weren't necessarily covered in the compulsory policy. They had deliberate and reasoned a purpose for making that selection. And under these circumstances, what ISOP wants to do would completely rob them of their right to do that.
It's so important. Let me go back to the question.
Yes.
And you pointed me to 118. If it's such an important factual issue, then why is its only support in this letter from the Workers' Compensation Unit Manager, which happens to not be signed, which references that they were advised by a Mr. Jensen that they intended this, but there's no affidavit from Mr. Jensen.
Mr. Jensen was no longer with the company and couldn't be located. So the affidavit that we...
The affidavit that you do have just says, I couldn't find any documents that suggested we did that. That's the furthest that you actually have.
Right.
I mean, if you had a conversation with him at some point, so I don't know how hard it would have been to find him if somebody found him and apparently got this statement. But I'm just saying it's so important, so where is it?
Right. Well, I don't...
Decide it without that?
I think that under the circumstances, I do think that, honestly, when we spoke with Progression about getting the affidavit from Mr. Davidson, at that point he could have said, oh my gosh, I can't believe we didn't know about this policy. I mean, I think that the record does support the showing that the insured knew what it was doing. And this is not a question where it was a complete oversight and they failed to realize that they had two policies that they could make a claim under it.
And you want us to address the question, assuming these facts could be established at some point?
Yeah, I don't think there's anything to, I mean, I think ISOP has said that there's no support in the record, but they've not countered with anything that would indicate anything other than that there was a reasoned decision by the insured as to get the two policies in the first place when they didn't necessarily need them, and to invoke coverage only under one of the two policies.
Let me ask you a couple questions having to do with our statutes. As I understand your argument, you're saying that basically, in order for there to be equitable contribution, the insurance company has to be liable to the insured, right? That's your first premise.
Right.
And that you're not liable to the insured because you weren't notified by the insured.
Because the insured never did anything, right, to including notice or...
Because you weren't notified by the insured in a way that called upon you to provide coverage.
Right, and I would just add, I mean, it's not just necessarily notice of the accident, but also providing any documents along the way and
Right, whatever it is that the contract says.
Sure.
But we have two statutes, one of which has to do with 15244, which provides for limited enforceability of notice provisions, right? Because it says, want of notice to the insurer shall not bar liability on a workers' compensation claim if it be shown that the insurer, insured, or agent had knowledge of the injury, or if it's found that the insurer was not prejudiced by such want of notice. And then there's also Chapter 175, Section 112, which states that the liability of any company under any other policy insuring against liability for loss or damage shall become absolute whenever the loss or damage for which the insured is responsible occurs, regardless of the failure of an insured to seasonably notify the insurer. So how is it that the want of notice itself is what determines whether or not the insurance company has liability?
Okay, well, to address Section 44 first, that actually deals with the notice of proceedings to obtain compensation, and those are not at issue here because this was not the issue was not the employee's notice of a proceeding to obtain compensation under the Industrial Accident Board. So I would submit that limitation on the notice requirements doesn't apply to this situation. I'd also, aside from Section 6 of that chapter, which requires the employer's first report of injury or fatality, that specifically says in the statute it has to go to the insurer. Section 7 provides that the insurer's obligation to pay benefits to the employee under the Act is triggered by receipt of that notice. So I would say, in two very different and significant ways, the Massachusetts framework is not like Utah, and Massachusetts requires some notice by the form, and then but that goes to the insurer. It anticipates notice to the insurer, and it doesn't impute it for the purpose of the notice of the injury. As to the proceedings, there's a little bit of a different notice requirement, but that's not an issue at this case. And if I can address just Section 112, that has to do when an insurer is denying coverage to its insured. And as the district court pointed out in its decision, the rationale behind that statute and behind the cases, like Johnson Controls and Darcy, where there has to be a showing of prejudice before an insurer can deny benefits under the policy, the reason for that is to prevent an insurer from denying the insured that which the insured paid for based on a technicality such as late notice when the insurer was not prejudiced by the absence of the notice. And in this case, Great Northern has never denied coverage to its insured. And so our position is that those cases, the reach and apply cases, and
Does
that
it deny
statute,
liability?
it's never even gotten that far. It's never even gotten that far. Because the insured has never done anything to indicate that it is sought coverage in any respect from Great Northern for this claim.
Okay, thank you.
Thank you.
And we'll take our morning break.